Okay, welcome everybody. So today we're here for social media policies, policies before posting. This is becoming a pretty big issue. It's one of those issues that kind of started small and this has kind of just gone up on this angle through across industries. It's not just public entities that are concerned about this. It kind of crosses many industries, especially with during the pandemic, the emphasis on virtual activities, as well as the importance of social media for many social service and kind of public protest purposes. So today's session is really going to be emphasizing some policies and some issues that libraries need to consider in embarking on a social media presence. There's a lot, so I tried just to pick those policies that are kind of the most important and the ones that tend to be the most common, but this is by no means an exhaustive list. There could be some others, and the law on this is rapidly changing. Right. So even resources, when I was doing some research for this, even some resources that were from just a few years ago are no longer accurate. So, this is one of these things that, changes, but the general principles of the idea of the things that you should be considering. Okay. So the actual details of the rights or wrongs of those things can evolve via case law and statutes. But the fact that you should be aware that you need to look into some of these things before you make decisions, or that you need to have policies on these things, that is not going to change. Okay, so as most of you should know or do know, my name is Clare Membiela. I'm the library law consultant for the Library of Michigan. My job is kind of like the law librarian for public libraries and for libraries across the state. I help libraries across the state understand the legal issues that could impact them and provide them with information on some of their options and some of the things that they can do to address those issues. This is my disclaimer because I am dealing with legal issues. I have to remind you that although I have a law degree, I'm not your attorney. I cannot be your attorney. If you have further questions, or if you feel that perhaps your library is in some kind of trouble or may have some serious issues regarding this topic, you need to contact your attorney. I also always recommend, one, that every library have an attorney. You don't have to have a retainer with an attorney, but please become acquainted with one so that if you need to, you have someone you can call. And when you have an issue, you're not scrambling to locate an attorney. Also, really, attorneys should be reviewing policies. I would recommend that you have your attorney review your policies every few years, particularly if you change them. They should be reviewed when they're changed. A policy like your social media policy especially should be reviewed by an attorney because of the volatility of the law right now, and because the ramifications of a mistake can be pretty large. So for the purposes of this presentation, when we talk about social media, we are talking about any platform open to the public where the public can interact and post content. So we're talking about situations where there can be a back and forth, as well as situations where the library can present materials to the public, right? So anybody who goes by the web page. In instances where you have a password protected space, like if you require your patrons to put in a library card number in order to access certain things, that's a little bit different than what we're going to talk about today. Some of these policies still apply, but a lot of the legal issues, a lot of the bigger legal issues are not exactly the same for those spaces because they are limited. They're not open to everybody. So today, mostly what we are discussing are open social media. So your presence on things like Twitter, TikTok, Instagram, YouTube, and that would include posting of presentations on YouTube. So, that's pretty much the kinds of things that we are talking about right now. So why do we need policies? I do other kinds of policy presentations, and one of the things I talk about is, do you really need a policy? And a lot of times, libraries already have so many policies that sometimes it's good to take a minute before you come up with a policy and see if the issue can be covered under an existing policy. Well, to a large extent, in this particular topic, it's a little bit different. The policies in this particular instance often have to be tailored to most of them, not all of them, but most of them have to be tailored specifically to the use of social media. And these policies are important because, first of all, hopefully they ensure legal compliance of the library and the staff with in their social media activities, right? So they ensure that the library is going to, and the staff are going to be following the law and doing the right thing. That is going to protect the library from liability, right? So it's going to protect, hopefully, from lawsuits, which could result in, a loss of reputation. It could result in huge monetary loss, as well as individual harm, right? It can affect someone's, not only their emotional well-being, but can also affect their job or their professional life. It also protects the library's reputation and their brand. So, if you've worked hard to have your library be presented in a certain light, you want to make sure that your social media presence carries that through, right? You don't want to have spent all of this time and money on logos and certain colors and fonts and making sure that all your documents and posters and brochures and bookmarks look a certain way, only to get on social media and not pay attention to those details. The idea a lot of times, as far as marketing is concerned, is to have the public recognize the library as a complete package with all of your kind of marketing materials. So this would make sure having certain policies for certain kinds of content is going to make sure that your library protects that brand and make sure that the library is presented to the public in the manner which it wants to, the staff or the board want it to be presented. It also protects, again, your brand. It protects your reputation. It protects the agreement that you have with the community to provide them with, valuable and service that is accurate and ethical and has integrity and is open to everyone, and in other words, that it represents the library's ideals, ethics, and mission. And lastly, it protects library staff and board from any kind of personal liability and hopefully personal attack from members of the public or others. So types of policies. Well, I broke them up into two broad categories. I broke them up into external policies and internal policies. So the external policies largely have to do with things like, the actual social media platform, things relating to activities on the social media platform and the things that the members of the public see. Where internal policies would be more like employment policies and things that mainly affect the internal staff or the internal workings of the library. So when we talk about external policies, one of the first things we have to look at are, which platforms are you going to use, right? So which types of social media is it that you want to embark on? There's a lot of different options, and the different options each have pluses and minuses. So if you've ever been on TikTok, you understand that that's the kind of platform that may require a little bit more work than, say, Instagram or Facebook, right? Which are more static. You post content and it sits there for a while. Things like Twitter and things like TikTok are things that move, right? They're things that the activity, the postings can change from minute to minute. And what can be very important there is being fresh, constantly putting out content. And that's not to say I'm not a social media expert by any stretch of the imagination, but even in the more static services, you still want to make sure that you have relatively fresh content. You don't want to just leave something there for, for years, but it's not as perhaps labor intensive as Twitter or TikTok, where you want to constantly have things, going out. You want to make sure that, so you want to look at your capability, look at, what kind of staff do you have? How well can you do it? You don't want to do multiple social media platforms if your staff can't support it, if you don't have enough hands on deck to do it right, because that can also affect your brand and affect your reputation. And then if you have too many people doing too many things, things can get a little sloppy and things can get forgotten, like reposting of problematic content that can open up the library to anything from, a libel claim to a First Amendment claim if something is taken down. When you look at these platforms and you're deciding which kind of platform you want to go with, you want to make sure that you do a really thorough kind of evaluation of the platform. Now, in your personal life, you may use these and you may think, oh, I know about these. But, how many times have you really read the user guidelines and the licensing and the copyright notices for Twitter or Facebook to understand exactly, according to that product, what can be posted, what can't be posted, and what are the requirements for the users for that platform? And how does your library and your library's intent and the desires and their expectations for this social media activity, how do those align with those requirements? Also keeping in mind that you're a public entity, right? So if the platform has certain privacy guidelines that may not necessarily mesh with the library's ethics, or the library's mission, or I would say Library Privacy Act, but in most instances you're probably not going to be posting names of people. So that's if you post photographs of people in the library, that could be a concern, and we're going to talk about that in a little bit. So you want to, again, review use guidelines and privacy terms. What kind of information does the platform store? What does it hold on to? Your style and brand standards, right? So, again, this is about your image, your outward presentation. Do you have logos? Do you have certain colors? Do you want to develop a logo? How big is your logo? How is that logo going to be used? How do you not want that logo used? Your language, style, and tone, right? Are you going to have a very informal presence, where maybe the person who is posting for the library uses slang, or uses abbreviations, or uses emojis? Or is the library going to go a little bit more formal with it, and you want to make sure that, for example, all of the grammar is correct, all of the spelling is correct? So those are the kinds of things also that the library wants to think about, right? What is the tone you want to set, and how strict are you going to be with regards to the language of the posting? You want to make sure that there is a consistency of message, right? And we're going to talk a little bit about, who gets to post. But, if you have multiple people posting for the library, you want to make sure that their styles don't clash, and that one person isn't posting one thing and someone else posting, the opposite, or a conflicting or a confusing posting at the same time. That's going to confuse your audience. You want to make sure that you keep an eye out for inclusivity and bias, right? Again, this is the kind of thing that you would make a decision on. Or how are you going to use pronouns? Does your library have a policy for that? Does your library have a policy with regards to inclusivity and bias? And how are you going to address how those things can be revealed in social media postings? So those are, things that have to do with language. Now you want to look at who, you want to have a policy on who gets to post. And this is actually very, very important. The fewer posters, the better. In general is the preferred way to go. So are you going to have staff post? Is your board members going to have ability to post? Are you going to share your social media with your friends group, or are they going to have their own social media? They should really have their own social media account. The more you limit the number of posters, the safer and more secure your site's going to be, and the higher the probability that you will maintain that consistency of message. However, you have to weigh that against the amount of work it could be, right? So you're not burdening just one employee with everything. So again, this is kind of a decision that goes to what is your expectation for social media and how many sites are you going to be on? And then, you could consider a primary and secondary content manager. If you're going to have multiple platforms, maybe you have, a secondary manager who that is in charge of each individual, and then you have a primary who keeps an eye on everything and reviews postings for things like consistency. There's many different ways to do this, and you can reach out to peers and see how they do things and how successful they've been. But again, you want to really think about the idea of what your expectation is versus what are the tools you have at hand, what are the resources you have available. And from if you personally are on social media, again, as I said, this is something that could take up a lot of time. And because you're the professional site, and because it's for a government entity, it's likely that you'll have to spend more time on it than you would likely spend on a personal social media page. You want to make sure that whoever you do assign to handle this is completely trained, not only on the policies and expectations, but also on the applicable laws that impact social media as far as libraries are concerned, and some of the things that we're going to talk about. And then you want to talk about what's going to get posted. So not just the language and the color and the logos and how the look is presented, but actually what the content is going to be. And some of the things you need to consider in this area are you need to consider things like copyright and trademark. And this is huge. We've talked in the past about, making sure that you're careful about images, because there are programs that crawl the web that look for images that are unlicensed, and then the entity, the library, or the other entity that is using the unlicensed image will essentially get a bill saying, oh, we noticed you used our image, this is how much it's going to cost, and it can be thousands of dollars. So, you want to make sure if you're going to have an active social media presence and you anticipate wanting to use images, then you're going to want to invest in some kind of image, licensing an image product like Getty Images or something else. There are plenty of free options for images like Pixabay. There's some Creative Commons content, and there are some others that I'll put in the resources that you can use that are, sometimes they ask for attribution, but you don't have to pay to use them. They're freely available. So you always want to work towards those instead of using commercial content. And that is also especially true if you're using licensed commercial content. And what I mean by that are things like Disney images or Lucasfilm images or DC or Marvel images. If you're using, or TV movie characters, if you're using, those kinds of images, you want to be extremely careful. It is pretty much advised not to use those images except with permission, particularly if you're going to be posting them on social media. Another issue is, book covers. Now, most of the time, even though technically book covers are considered, artwork that would be owned by the artist, it is generally accepted that book covers are also advertisements for the book. right? So generally, the leading theory is that if you post a book cover, you're okay, because it is unlikely that the publisher of the book is going to come after you for using the book cover without a license, when what you're doing, you're a library, and what you're doing is posting the book cover, and you're advertising the book. You're saying, we have this book. So generally that should not be a problem. The thing you want to be careful of, though, is to make sure that any artwork that you do use is presented in a manner that is respectful of the artwork and doesn't denigrate the artwork. You want to be careful about, sharing someone else's posting, even from another library, because you want to make sure that that artwork is vetted, right? So if you're using, if you're, taking a post from Facebook and you're, reposting it on your site to say, hey, look at this neat idea, or look at this, cool thing that we're going to do too. Be careful if they have a licensed image in it, because you could still get in trouble for that. So, you have to be, again, because you're a government entity, you have to be extra careful about those kinds of things. So you want to make sure that you have a policy that governs for the people who do the posting and for the people who are going to do the sharing of information from other sites, that they understand, when should a red flag go up when they're going to share content? Can they just willy-nilly pull links from anywhere and repost them on your social media, right? There are some sites that when you pull links, they want attribution. So, and you can usually find that out by when you go to a website and you see a link on that website. Usually there'll be, like a note, like a licensing note or a copyright note at the bottom of the website that will kind of give you an idea of how the owners of that website would like this content to be used and shared. So, that's a concern. It's not the biggest concern, because we all link content. So, this is not on the scale of concerns, this is not the highest, but it's something to be aware of. What's a good idea is for your content managers of your social media, have like a manual for them, right? And then in that manual, there should be, different, tabs or different, organized content for all of these different concerns. You want to fact check. So if you're reposting and linking to other things, and you are coming across controversial content, which is especially true today, right? If you see something, or if your content manager sees something that doesn't seem quite right, or seems too good to be true, or seems a little bit out of this world, it probably is, right? So you want to be very careful about perpetuating harm, right? You don't want to perpetuate anything that is false, whether it's misinformation, misrepresented facts, whether it's information about someone, even someone who is, well known, or a political figure. You want to be careful about that. You want to make sure that when you reuse content, you reuse it from reputable sources, and that your content managers have, to the extent possible, vetted it, right? So fact checked it. So in other words, if it smells kind of funny, it probably is funny. And you may want to err on the side, or tell your content managers to err on the side of not reposting things that seem a little bit odd, right? Particularly if you're talking about photographs that may seem humorous, or memes that may seem humorous, because that could also, in addition to, maybe misrepresentation, you could get into an issue with defamation or libel. So you want to be just, very, very careful. So let's talk a little bit about libel. So right now on this topic, libel in social media, the law, this is one of those areas where the law is really evolving. So libel is written, right? So libel is defamation in written form as opposed to slander, which is spoken. So it's been held that libel carries into the online environment. And, you have to be, careful. Again, this goes to being careful about what you repost. If your content manager is reposting content from, like say Facebook, and they're reposting content from another Facebook page where someone says, the governor is going to do this, or Whitmer is this, or even, this person on the school board at this school has been convicted of this crime or has been arrested. Unless you've verified that that's true, you want to be very careful about posting that kind of information. Any information that could harm someone's reputation, or harm their ability to get a job, or harm their business's ability to make money, or harm their businesses, like they could lose customers. Those are the kinds of things you want to be careful of and avoid. And, sometimes when there's conflict in communities, there's a temptation to, provide information that might be considered news, but if it's not from a reputable source and it's not fact checked, then you want to be very, very careful. Another thing you want to be careful of with this is liking. So this is very, very new in the law. And right now, most of the case law is out of this country. It's not in this country, but it's starting to kind of grow. So people are watching for it, and you don't want to be a test case. And that's the idea of whether liking a libelous post could put you at risk for libel. And the courts in many of these other countries have said, yes, it is possible. So, again, you want to be careful and make sure that you have guidelines for your staff on what to like, right? So this kind of also goes back to a library staff member doing their job needs to step away from their personal points of view, their personal political points of view, their personal beliefs. They need to really be very objective and not treat this like it's their personal social media account. Now, a defense to libel is the truth, right? Something is not libelous if it's true. But sometimes that can be difficult to prove. But if in your fact checking you find that something is in fact the way that it's presented, then it's not libel. But again, this requires fact checking, which could take a lot of time, right? So again, these are some choices that your content managers have to make. Am I going to spend 2 hours fact checking something, or am I just not going to do it because it just seems like doesn't smell right? So I'm not going to repost this. The other thing to keep an eye for on your forward facing, your external facing pages, and I think this tends to occur more on things like Facebook than Twitter, is be aware of providing some kind of commercial benefit, or in the law what they call pecuniary benefit, to others, right? So the library as a public entity cannot what is called share state credit. And that means that the library can't, by benefit of its resources, provide a private entity with some kind of benefit that could be valuable to them, like could provide a monetary benefit. Now, I'm not talking about lending books or programs or something like that. I'm talking about things like advertisements, right? So on your Facebook page, don't post that, there's a member of the community who makes wonderful blankets and she's selling them for Christmas. Don't post about a board member's business, right? If whoever has access, so your content manager, or if you have board members that have direct access to your social media, make sure they understand that they can't post information about, their businesses, or the fact that their, granddaughter is selling Girl Scout cookies, or even that there's this fundraiser at this place. So the library website is not the place for community news, right? It's the place for library information, information pertaining to the library. You don't want to use library resources or staff time or resources for the benefit of other parts of the community or your municipality. They have their own social media presence. You want to use it for library benefit. So you want to be careful about that, especially where it comes to like commercial benefit. Okay, that's a really, and you may think, oh, you know, it's not big deal, but it can be a very big deal. Okay, so those are kind of overview of external policies. There's one big one that we haven't gotten to yet, but we will, and I'll let you guys try to figure out what it is. We'll get to it in a minute. Internal policies. So we're going to start with employment policies because these can be, again, they're a little bit all over the place. First of all, when you have employees, they have their own social media accounts, right? And you may have heard in the news that, you know, what extent can someone's personal postings about their job or about their boss be, you know, restricted by their employer? And the answer is very, very, very minimally. So me or you or your employees, we all have a First Amendment right to post on our personal social media. And we can post anything we want. Now, we still are beholden to things like libel, right? Individually, we have to be careful of libel. But we can pretty much post, you know, whatever we want. Now, again, understanding that, you know, if you post something about your boss that is particularly, you know, horrible and untrue, then you could be held for libel, right? You could be sued for libel as an individual. But as far as the employer governing this, it's very, very sticky. Okay, there are some mitigating factors, things like, are they doing their social media? Are they posting personal social media on company time? Are they using a company device? So if you provide a cell phone to staff, or you provide a laptop or an iPad, and they use that you know, device to post negative content, then that's a little different than if they're at home or if they're at lunch or off the clock on their own personal phone or device posting to their personal social media. There are some guidelines you can have for this, but you want to be very careful about drafting these because courts, it's really a very gray line, and there's a lot of kind of buts here. It's not even a very clear line that if your employee is on company time and posts something negative, that, you know, you can, you know, fire them, or because what if it's whistleblowing? So you really want to talk to your attorney about these kinds of policies. And if you already have a policy like this, I would strongly recommend that you make sure your attorney has taken a look at it, because you know, this really gets into probably the highest level of First Amendment protection for your employee. So you want to be careful about these kinds of policies. You want to make sure that your employee handbook has some written policies or expectations for employees, especially those that are your content managers in your social media, for, you know, posting outside of work. You know, because what if they're trying, you know, they just are trying to do a good thing and they want to post something that they posted at work on their personal social media. So, you know, there could be some ramifications to that. It's not necessarily illegal or anything like that, but depending on their social media account, depending on how they present themselves on social media, depending on, you know, the way their personal page looks and the audience that it attracts, you know, there may be a question of whether or not the library, you know, wants their brand to be posted there. So again, there are some, you know, maybe some policies and procedures that the library would want to, or expectations that the library would want to talk about. Records retention and FOIA. This is also something kind of new. So social media postings are considered public documents. So you have to retain this information according to the retention schedules. And if you have if you permit posting on your page, so if you permit the public to back and forth on your page, then those postings also could possibly be FOIA'd. So you have to come up with a way to retain some of these, information, whether you have an archive. And I looked into this because I'm not as familiar with the technical side of this in terms of how this stuff would be kept. And apparently there are services that do it. And some people just print it out and, on paper and save it, which is also fine. So there is a, Michigan has a records management office, and part of their job is to consult with other government entities on how to comply with FOIA and the records retention requirements. So this might be one of those areas where you can call them, and it's no charge, and I will put the information in the resources. You can contact them and say, hey, we have an active social media presence. What is the best way for us to retain this? So that, you can at least make sure that, to the extent that you're able to be in compliance with that. Security, but again, the FOIA, that's all kind of new and developing in the law. But so far, including in Michigan, there are cases that say that digital content, and the case was on email, digital content is a public record. So even though there isn't a specific case in Michigan on social media, most of the attorneys and the legal information that I have read recommends that entities treat it like public information, because the expectation is that if a case should come up, it will be declared a public record. And then you also have to look at security. So you have to look at security from the technical end. What is the cybersecurity? What does the security of your network look like? What is the security of your internet provider? What is the security of your individual devices that your staff may be using? And this is something you should already have looked at for purposes of the Library Privacy Act and your patron content that you maintain on your network. So hopefully this is something that you're already pretty familiar with. Michigan has a couple of laws that deal specifically with personal information and the protection of personal information by entities that do collect personal information. Libraries are largely covered by the Library Privacy Act, in that if you are compliant with the Library Privacy Act and you have a secure network, you are largely in compliance with the, it's called the Identity Theft Protection Act. However, when you're talking about your online social media presence, you want to, again, this is another reason why you're going to take a look at the privacy requirements, the privacy guidelines stance of the product that you're using, as well as the individual devices that your staff are using to do it, as well as where they're doing it, right? Are they using public Wi-Fi in the staff reading room on an iPad to do it? There may be some security concerns there. And this is a question for your technical person. If they're doing it on a secured if they're doing it on the network, or they're doing it on, like a cell phone that's connected to a service provider like Verizon or AT&T, then that's a different situation than if you're on public Wi-Fi. Again, depending on how secure your public Wi-Fi is in your library. But if your staff member goes to Starbucks or to Bigby, or, is at a conference and is live tweeting and is using public Wi-Fi in a conference center, theirs may not be nearly as secure as yours. right? Or on an airplane. Or so those are some things that in your manual that you're going to have for your content providers, those are some things that you're going to want to address. You know, be careful about posting when you're in an unsecured network. And you know, or at least be careful what you post when you're on an unsecured network. You want to make sure that your accounts are secure, right? That you have two-part just went out of my mind. Authentication. That's it. You have two-part authentication, that you have all of this, as many, you know, the required security options chosen, that not everybody has access to the password and to the account information, that information is kept to those people that need it. So to the content providers and those people that manage them. So, you know, those are the kinds of things that, you know, as far as security goes, that you want to make sure are, you know, on your radar. You want to make sure you have a policy on whether or not a personal device can be used from, you know, if an employee is at a conference, can they, you know, so can they post to social media using their personal cell phone? And if they do, what are the ramifications of that? Again, this could also, you know, affect the, you know, ability, you know, as we talked about before, you know, the restrictions of, you know, someone doing personal things that can get very muddy if they're using a personal device for everything. So you want to clarify with your attorney whether or not that's a good idea to, you know, because again, on top of all these other issues, you have the FOIA issue, which is if you're using a personal device for your, you know, public entity work, then that opens that personal device to, you know, a subpoena for documents that might be, you know, requested as part of a litigation. It may open it up to FOIA. So, you know, those are the kinds of things you have to be careful of and address if you're going to be permitting your employees to use their personal devices. Okay, this is the one area that we did not mention in external policies, and I kind of saved it towards the end because it's a big one. And this is one of the biggest questions that I get in terms of social media questions, and that's managing public comment. So the big question to ask yourself is, should you permit public comment on your platforms? On Facebook, on Twitter, should you permit people to comment on your posts or to post things themselves? The big problem with this is that because you are a government entity, obviously the First Amendment gets involved, right? Because you're a government entity. Now, I'm going to go to the next slide. I will be back to this one. But when you're a government entity, so we get into the First Amendment public forum question, right? So there are basically three different kinds of public forums. And you may remember that libraries are limited public forums, right? So that means that we can impose reasonable rules and restraints. When you open up your social media for public comment, that converts that space into a designated public forum. A designated public forum is the second widest type of public forum. So you have traditional, designated, and limited. Traditional public forum is the broadest public forum, has the most free speech protection. That's things like the lawn of the Capitol or the public sidewalk or a public street. Okay, these are things where the expectation is anybody can say anything they want. You can have a sign that says anything. Designated public forums are forums that a government entity has opened for public expression. So it's a space that may not normally be open for public expression, but the government entity has opened it up. And those might be things like a meeting room that a government entity has opened up, or a theater space that the government entity has opened up, like a community theater space. That's how courts have interpreted social media public comment spaces. So that means that when you open that public comment, anything that anybody says is protected by the First Amendment on a level similar to what it would did if they yelled it in the street. And that means that you have very little, very, very few options for removing public statements from your social media. So there are ways in which the First Amendment can be restricted, okay? So you can restrict comments in your public comment, okay? So the limits, or remove, actually, you can remove comments that are, you know, defamatory, right? That are libelous. But then again, you'd have to know for a fact they're not true, right? So that might require a little work. Fighting words, and fighting words are interpreted as language that would is very likely to incite a fight, or, you know, a physical altercation, not just a word fight, but a physical altercation. And, you know, that could be, you know, lots of things. The case law on this is you know, it kind of depends on a community. It could depend on you know, the actual language that is used. But the one thing is this is actually, it's not just any, like, you have to be really careful with this. And the problem with some of these is that you can't really define them until it's gone through a court. So it's really a court that decides whether it's fighting words, or a court that decides whether it's inciting speech, or a court that decides whether it's obscenity. You deciding is treading a very sticky path, a very gray path. So again, fighting words is anything that might elicit or cause a physical confrontation. Inciting speech is speech that would incite illegal behavior. So, you know, someone calling for everyone to, you know, go to a certain place and smash windows, or, you know, to, you know, harm somebody, or to, you know, string them up, or, you know, anything like that would be considered inciting speech. And then, of course, there's obscenity, which has a really convoluted test under the Miller case, and may not be what you might think, right? Obscenity is not simple, you know, someone cursing. Obscenity is not necessarily bad language. Obscenity is, you know, is rises to a particular level. So you have to be very careful about removing things just because somebody used an inappropriate word. There are some things that I've read that suggest that if you have content guidelines as part of your social media, you know, in interactive portion. So for example, as part of the public response or public posting, you have participation guidance that, you know, says, you know, this must be on point. This must, you know, have to pertain to the library. You know, you cannot post defamatory content. You cannot post, you know, content that is violative of copyright or trademark, or, you know, if you create a good policy, then it may be possible to remove posts that do not conform with that policy. But that is something I would definitely talk to your lawyer about, because I'm finding some different opinions on that. Some sites I've gone to, including some sites of state libraries, employ that type of option. And they say, this is what we will accept, this is what we will not accept. So, but again, you want to just be careful about that, especially nowadays when there are so many hot topics and so many, you know, kind of hot button, you know, members of the public. So I would definitely, for sure, double check with your attorney on whether or not that kind of policy can help, and if it does, exactly how that should be worded to protect you. And then you want to make sure also that your content managers have explicit instructions and training on when to remove a post and when not to remove a post. And what is the procedure for removing a post? Okay, do they need to notify the person? Do they not need to notify the person? Do they need to save the message? Do they not need to save the message? So again, those are things that I would double check with your attorney. You cannot limit viewpoint. Okay, so once, no matter what your policy says, if someone comes up and says the library is terrible, they don't deserve their millage, they're just a bunch of liberal, yada yadas who, are infesting our children with critical race theory or whatever, you cannot remove that post because that would be removing it based on content. And that's just absolutely not permitted. And again, depending on the guidelines that you post for public content, the same goes for certain aspects of what we may call hate speech. Some of it would likely be protected under fighting words or inciting speech, but maybe not all of it. And again, some of it could be couched as viewpoint. So those are also questions to make clear with your attorney in terms of, what precisely are you able to do and what precisely should you not do. And then looking at all of that, determine for your library whether or not public comment is worth it, right? Because depending on the objective of your social media presence, maybe public comment is not worth it. Right? It doesn't mean that you can't include the public in your, in your library marketing. There are other things you can do other than just having, people just randomly put whatever they want on your site, because you also run the risk of people who are way outside your community posting things on your social media nowadays just to stir up trouble. Like, oh, I bet your library has these books and you should look at them because they are, obscene or pornographic. So these are some discussions that you have to, really consider, and it may be a shift from what you always thought or what you do now. You can always, see if the platform you are using has the option for a public poll where it's, you could have a question of the day and invite your users to vote on it. You could have a readily accessible option for inviting feedback where you're inviting comments, but those comments do not get posted to the general public. Maybe you solicit comments from your patrons, and then you can quote some of those comments on your social media page. Or you can, curate some that maybe are critical of the library that you'd like to address, and some that are positive about the library. When you are doing YouTube, you may want to consider ensuring that your participants are muted during whatever program you're recording. Unless, it's a question answer thing. You also, you could post a Q&A from the library. So if you are getting feedback from your community that, there's some negative and there's some positives, maybe create a Q&A where you say, hey, we're hearing some feedback, or here are some things we're hearing around town, and we'd like to address them. Again, if you are going to open up comments, just make absolutely sure that your ducks are in a row, that you understand what's allowed, you understand what's not allowed, you understand what your options are with respect to problematic postings. And then you follow those, you follow your own guidelines, and you ensure that your staff is also trained and understands those guidelines. And as I said, please double check with your attorney. Some of this is just, it's really something that you don't want to just do all by yourself. Even I would not do it all by myself. There's too many strings here that go in a lot of different legal directions. And, you know, I wouldn't feel comfortable completely developing a policy all by myself without checking with at least one or two other lawyers to say, what do you think about this? I want to go back to that slide. In addition to commentary, I mentioned your guidelines for participation, the procedural for removal, and consequences of continued infractions. Part of this whole scenario is that if you open up for public comment and if you create guidelines, you want to make sure that the public knows what those guidelines are. So they really need to be prominently posted so that members of the public understand that if you don't follow these guidelines, then, you know, we may boot you out. And then, you know, they're on notice. They're not surprised. Okay. Let me go back on track. Okay. So the general recommendation from all of this is that it is probably not a good idea to permit public response on library social media. We already looked at the slide. So again, this is not saying you can't do it. It's just saying, you know, just please be careful and make sure that you talk to your legal counsel before you just willy-nilly do it. You may also want to talk to your municipality. Depending on the establishment of your library, double check with your municipality and see if they have a policy on this. And you may be able to, you know, once you review it, you may be able to piggyback on their policy or use their policy. So let's talk about, you know, FOIA and the Open Meetings Act. We talked a little bit about FOIA. So we mentioned that, you know, there is some case law out there that says that social media accounts and postings are covered by FOIA. So we talked about archiving. We did not talk about Open Meetings Act. So this is something for your board members. They're going to want to be aware that all of them talking on the same Facebook page or Facebook Messenger, if there's a quorum, could be considered a violation of the OMA. They would need to have a public meeting. If they're discussing library business and there's a quorum of them on a social media site, then that could be a violation of the OMA. They need, you know, in terms of they would need to have a public meeting. It could also be if they're all just happen to be on library social media and, you know, maybe they're saying how great a library program was. Well, that's a different story, right? Because that's more of a social thing. It's quorum and it's what the content of their discussion is, right? So the same thing would apply if members of the personnel committee all got together and, you know, came to a decision as to who they're going to interview for a position, because the OMA says that all, you know, job interviews and all decisions need to be done in public meeting. So even though it's not a quorum, if the board has delegated to that committee decision-making ability, and if that committee is making a decision, then they need to have a public meeting, even though there's not a quorum. So doing all of this on social media, like Facebook, could also be problematic. So that's like another facet now to consider with regards to your board and OMA. So in sum, and I see we're just at 11 o'clock, you want to make sure that you create clear and comprehensive policies for your social media, not only to manage them, but also to secure them. You want to make sure that you involve your attorney in these discussions because the ramifications of liability are high, especially nowadays with everything going on and people, you know, waiving the First Amendment about, even if they're not accurate, even if something that you do is not a violation of the First Amendment, them, if someone were to take you to court, then, that's an expense and time that you just don't want, right? Make sure your policies are fresh, right? You can't just create these policies and then let them go for 5 years. This is an area of law that is rapidly changing. There are, like I said, the idea that you could that FOIA protects social media records is pretty new. And it's evolving. So and the idea of being alike being considered defamation is also something that is moving quickly. So you want to be careful. In fact, there was even one of the FOIA cases actually went to the U.S. Supreme Court. And it was a Donald Trump case. A member of the press had sued Donald Trump for blocking him on Twitter, saying that since Trump was president, that was a violation of FOIA. By the time it got to the Supreme Court, Trump was no longer president. And so the Supreme Court rejected it as moot. They wouldn't hear the case. But most, legal authorities, based on case law from other situations and other circuits, have said that it most likely would be considered a FOIA infraction. So there are cases on these topics that are starting to come through the U.S. court system. So again, you want to make sure that you keep yourself updated. Make sure that your library board and staff and anyone who's going to be involved in social media know what the requirements are, understand what the risks are, understand what to keep an eye out for, make sure that the training is updated, that they're just not trained once and then not again. Make sure that your content managers have someone to go to for assistance if they need something clarified. Monitor your social media, or make sure that you have somebody monitoring your social media, not the person who is posting, but someone else, to make sure that the guidelines are being followed, and to proactively be able to head off any major problems, and to be aware of changes in platforms and technology. These platforms change their privacy rules. They change all kinds of things, and sometimes it can be changed like, overnight. So you want someone who is going to be on top of that. And then, like I said, you want to make sure that any policies you have, such as a social media policy and a privacy policy, are posted to your website so that members of the public can easily have access to it and understand what your requirements are and can ask questions if they need to. Okay. Thank you. Here are my contact information if I can help you. I'm going to stop sharing and see if we have questions. It looks like we have some. Let's see. I'm going to go back. We're part of a co-op that has a program called Go Library Deals. Local businesses give discounts to those with a library card. Is this a problem? That's an interesting question. I might have to actually research that. I'm thinking maybe not, since it could maybe also be considered a service, but I'm gonna look that up. And that's from Jamie. I'm sorry, I'm having a little trouble seeing my screen. I don't know if it's the light in here. So I will look that up and I will send out a written request. That's actually a good question. I'm not sure. Isn't social media content saved online? Whatever makes it right. That's right. A lot of it is, but if this is FOIA, that implies you might have to get back to it. So the entity is going to want to understand how that is saved and how is it saved in a way that they can access it, because part of FOIA is that the public entity has to preserve it in such a way that members of the public can gain access to it. So it may be, if you know for certain that all your social media stuff is going, say, to the Wayback Machine, that may be an option. You're going to want to double check that with your attorney. But the idea is that not only do you have to preserve it, but you also have to make sure that it's accessible. How long with content need to be saved? I think that depends on the content. Anything pertaining to your board, like board minutes or board commentary, would probably have to be saved forever. For programming and stuff, actually, I should have looked that up before this. I did not. So let me make a note. I will actually find out and let you know. I am not sure how long it would have to be saved. As I said, some of this is so new. I'm double checking. I'm not even sure if I'll have to double check. I know it would depend on what the material is, right? So whether it's information on a program, hang on one second. My guess is that this is going to be something maybe like public, maybe like emails, since that's what the courts are looking at it as. Let me look this up right now. Since I have you here, this won't be hard. Okay, here we go. I think you could call this probably like publicity, which is permanent. Yeah, it looks like a lot of the things that involve like the public, like donors or are permanent. So for right now, I'm going to say based on this record retention schedule, I'm thinking that it may be permanent, but I'll do a little more digging here and see if I can find a closer category. But right now, it looks like it would be under publicity. But I'm going to do a little bit of double checking on that to make sure. Get hit by Facebook spammers. Yeah, probably the most complete way to deal with that is just not have commentary. If for things like Facebook scammers, which would most likely be covered under the illegal activity exemption of the First Amendment, I think that you're okay. But yeah, I mean, again, to just be on the safe side and for the hassle, depending again on what the purpose of your social media is, and how much traffic you get is another thing, right? So if you're a very big library and you get a lot of traffic on your site, then maybe it's a better thing to limit commentary, to not have commentary. If you're a smaller library and you don't get a lot of traffic, so perhaps the management of it is not going to be as onerous, then maybe that's a different story. But those are things that really you all have to decide in maybe after conferring with your attorney. But yes, I would say probably to Andrea, probably not commenting would completely take the problem away. But if you know for a fact they're a spammer, then I believe that could be covered under the illegal activity exemption. So you're probably okay to remove them. Does hiding a comment count as removing? Yes. If the public can't see it, like silencing it. What about images? Yes, you can have a policy. Your policy for your posting on social media can be whatever you want it to be. Within reason. Like I said, you can't police content. So you can't say, well, no images of X, but you could say flat out no images. Please don't post images, or don't post images or graphics or illustrations. Can we turn off commenting on some posts? But no, that's problematic. I would say it's all or nothing. Yeah, I think again, that kind of speaks to the idea that if you have very good comment guidelines posted, like, we invite comment, that we invite comment on our programs, we invite comment on the specific, programming post, or we invite comment on, particular things. But you have to be very careful with that, because you have to stay well away from viewpoint. So that's a little sticky. If there may be a way to do that, but if you want to do that, I would definitely talk to your attorney. Personally, I think that the safest thing is all or nothing, because you're putting a lot of responsibility in the hands of your content managers to make those decisions, which can be kind of stressful. So, in my mind, it's kind of all or nothing. Can government entities delete their own social media posts to avoid heated comments if they archive yeah, yes, yes. Yes, if it's your posting, you can delete it as long as you save it, so that if a member of the public contacts you and says, hey, I was on your website yesterday and I saw this, but it's not on there now, do you have a copy of it? So that you can, they can FOIA it. Michigan Activity Pass. Yes, yes. Because I believe that's a nonprofit thing, even though it's about getting discounts. It depends. Right. This depends. So I'm responding to Christine. She says turning off comments is contrary to the social media training I have received. The goal of social media is to encourage interaction. No comments equal no interaction. Also, I have been told that 20% of posts should be from your library and 80% from outside the community bulletin, like a community bulletin board. So there's a couple different things to unpack here. Part of this depends on what the purpose the library declares is your social media, right? So what is the purpose of your social media? If the library determines that the purpose of their social media presence is interaction by the public, then you can certainly open up your comments. The problem is you cannot remove comments. Removing comments is very, very, very risky. And even a simple Google search will bring that up, because what you have to remember is that you are a public entity. You are a government entity covered by the First Amendment. And opening up your comments creates a public forum, which means that it is subject to the highest court scrutiny that exists. And that highest scrutiny leans against deletion. So yes, if your aim as a library is to encourage this space for your community to interact, and I see the value in that, I'm not telling you that that's not valuable. My job is to tell you, here are the risks, and here is what the legal opinions are, right? So if you're more on the kind of that gives the wrong impression. If you're on the more cautious side, right, you're going to say no comments. And try to provide an alternate method for those comments, like polls. Like, if, however, your library really wants to have this open public space, which is great, then you have to be prepared for the downside of that, right? You can't have your cake and eat it too. A private company like Coca-Cola can have their cake and eat it too. They can open up public comment and they can delete whatever they want. A public entity cannot. So you have to take the good with the bad. You can have your space, but you can't delete. And the idea of 80 and 20, that sounds like a marketing thing. And that may be true. I'm not disputing that. But from a legal sense, if you get 50 of one and 50 of the other, you can't delete any to fix it, right? So, you pretty much take whatever you get. So if your social media is bombarded by, out of state people, if God forbid, you have a book challenge or something like that going on, and your social media becomes bombarded by, conservative think tank people and, Facebook people, and there's nothing you can do about that, unless it falls under one of those free speech exemptions. You have to just let it be. You can shut down your social media, you can delete the post and stop your account, but you cannot, you could turn off all public comments, if you get into trouble, but you can't pick and choose. And so that's kind of the point. It's really not from a legal liability standpoint. Most of the things I have read suggest that not having public comment is probably the safest method. Doesn't mean it's the only method. It doesn't mean it's the right method for you. So that's another reason why you want to have a conversation with your attorney, because it's all about aligning your library's expectations and their mission and their corporate ethics with the law. And because you're a public entity, that can be extremely sticky. What about having a speaker visiting from another organization or business? No. If you have a speaker come in and maybe you have someone from a database company, or you have a member of your local businesses come in, let's say you have a podcast and maybe you have a contributor or a large donor who came in and gave your library a lot of money, or sponsored summer reading, and you want to talk to them. Saying, oh, they are from this company and this company gave us a lot of money and we really appreciate it, is not an advertisement. If you say, now everybody go use this service, or we very much recommend that Bob the plumber, we very much recommend plumbing service and he does all of the library plumbing and everybody should go to him, that's a different story. In that place, you're using the library's goodwill and the library's good reputation to back a private entity. So you're using the benefit of the library's hard-earned reputation to benefit this other person. Thanking them for something, or just introducing them is not the same thing. That's fine. Okay, I think that's all the questions. Thank you very much. Those were great questions. I am going to look up the Go Library deals. I'm leaning on the side that it's probably okay, because it sounds like maybe like kind of a donation to the library or a service. And I think as long as the library doesn't endorse any one particular company that's involved in that and say, hey, everybody go to, this diner, I think you're okay. So I will do some research and let y'all know if that's incorrect, but I think as long as you don't endorse a particular company or single out a particular company for an advertisement on your site. Like, for example, we had a board member who posted on their library's social media site an advertisement for their family business. Like, that's clearly not okay. And I would not be comfortable even with saying Girl Scout cookies are now available, please buy them. I would not put that on your social media. If someone else posts that on your social media, depending on your guidelines, you may be able to delete it. But as long as you don't like it, or as long as you don't endorse it, even leaving that up is probably okay. If someone else posts it, again, as long as it's not a board member that posts it or not, but just a member of the general public posts it, and the library doesn't like it, or endorse it in any way, even that, may be okay. Highlighting individual locations and telling what kind of discount they give. That's kind of in a gray area. Again, if you're neutral as to whether or not they're a good company and as to whether or not the product that they provide is good. Or, you know, you say, oh, the library uses them. If you're just providing information, so you're saying these are part of these people are part of this program and this is how much they give off. That is likely okay because you're just providing straight information on the program. Where it could get problematic is where, you know, is if you say, please, you know, please go to these merchants who are part of this program. Please use this program. You know, that could be problematic. Now, if the library gets like a kickback or gets money back, that could possibly also change the dynamic a little bit. But that, like, you know, if you had an Amazon link that gave you money back, but that too is something that you may need to talk about with your attorney simply because of this lending of state credit. But generally the law says that if you're getting something in return, so if you're giving and you're getting, then that changes the equation slightly. So let's say if the library is getting money from this program, then that could be a different story. But if it's just a program and the only benefit of the program is that your patrons get money off, then I would not, you know, you can give basic facts, like this is how much they get off and these are the people involved, but do not put any kind of adjective or endorsement or, you know, please go use them. And yeah, I know it's very gray and weird. What about posting about a radio station hosting a local Olympic medal winner? Well, that's kind of news. So that's, you know, that's kind of a notification of an event or a news item. So that's probably okay. It's all about whether the entity you are mentioning is getting financial gain. But if it's an event, you know, then that's, you know, that's a different story. Or if it's news, then that's a different story. Okay. Thank you very much for attending. And I hope, again, y'all have a great weekend. I appreciate you being here.